Very good evening to everyone. And I would kindly request Justice Suryakant to kindly light the lamp and other dignitaries to join him on the stage.
May I request Justice Verale and Justice Vishwanath and the Attorney General also to come for the lighting of the lamp.
I would request the dignitaries to kindly take the seat. I would now request Ms. Nandini Gore, who's Secretary of Nivaran, a registered body for mediation in India, to come and please felicitate our chief guest for today, Justice Suryakant. Ladies and gentlemen, esteemed judges of the Honorable Supreme Court and the High Court, and learned Attorney General, and distinguished members of the bar, today I welcome you all for the third Soli sorabjee Memorial Lecture being hosted by the Commonwealth Lawyer Association in collaboration with the Society of Lawyers in India, which is fondly referred to as Soli, and also in collaboration and partnership with Nivaran. Nivaran is a body of mediators, a registered body which is working from tirelessly from past 4 years towards building a mediation friendly environment across India. And not only in India, they have also started offered courses during the summer vacations in the Supreme Court, and also of courses are being offered online. So today we have gathered to celebrate and commemorate the life of late Mr. Soli Sorabjee. Now, we all know Mr. Sorabjee as one of the leading lawyers of the country who had played an important role in development of constitutional law and human rights in India. And apart from law, Mr. Sorabjee was a jazz enthusiast and also loved poetry. One of my interaction with Mr. Sorabjee was when I had asked my senior, Mr. T.R. Rujana, to kindly arrange a meeting because I had a book written by Mr. Sorabjee and I wanted to get it inscribed. So I went and met Mr. Sorabjee, and I was sitting for more than half an hour listening to him talk about cricket, poetry, everything. And I was just watching him speak, and I was in awe of the man because of the life he has led. And that was the day when I also met Mr. Santanan Krishnan for the first time. And it is I think probably it was for that meeting that I am standing today and moderating this session. And today with us, we have Honorable Justice Suryakant, Honorable Judge of the Supreme Court, who graciously accepted our invitation to speak on a topic which was very close to Mr. Sorabjee's heart, human rights and its development in India. Joining him on the podium, we have three prominent Supreme Court senior advocates. We have Mr. Jaideep Gupta, we have Rakesh Khanna sir and Nisha Bagchi ma'am today, who have worked closely also and have worked with Mr. Soli Sorabjee, and their life has also been touched by Mr. Sorabjee, and who will be discussing about their life and reflections of Mr. Sorabjee with us today. And we are also honored that today we are also joined by Mrs. Zina Sorabjee, wife of Mr. Soli Sorabjee, through online, through virtual platform. So without further ado, I'll invite Mr. Jaideep Gupta to please come on the stage and please share his personal reflections on Mr. Sorabjee.
Good evening, everybody. Chief guest for the day, Justice Suryakant, Justice Vishwanathan, Justice Varale, the Attorney General of India, and Mr. Sijoria, Rakesh Khanna, and Nisha Bagchi. I propose to be very short today for two reasons. One is that in this audience, there is not many people who do not know the things that I know about Mr. Sorabjee. Everybody knew him personally. Everybody knew his life, knew his work, knew his presence. And so there is not much that I can say which will be of any great import. The other reason, of course, is that we have a very eminent speaker today, and I'm sure that you are waiting to hear from him. But since I have got an opportunity to say something about Soli, and we always called him Soli, though he was a generation ahead of us, was my father's contemporary. But it is the tradition in Bombay, and particularly amongst the Parsis, to refer to old and young by their name. So I got into that habit when I came to Delhi, and we always referred to him as Soli. Soli was not just a source of inspiration generally, but he was somebody who actually trained us because even though I was not in his chamber, it wasn't very much different from being in his chamber, because day in and day out we would work together. His preferred time of conferences was in the morning, so there would be a long line of us waiting at around 8:30. Each conference would last only about 10-15 minutes, You had to briefly tell him everything precisely, otherwise he would not entertain you. And you learnt the art even in having a conference with him, because in a conference he would tell you the importance of formulating propositions. Now, as juniors, we had this tendency of being knowing everything about the papers, of course. You knew the facts, you knew the law, but you didn't know what to do next. You're supposed to formulate a proposition, and that proposition must be a legally or a forensically sound proposition. And quite often we would mumble our way through that, and he said, "Tell us, what is the proposition?" And then he would make a small note on the inside page of his brief, which I believe his original juniors like Mr. Harish Salve and Mr. Gopal Subramaniam referred to as his paw marks. So they would, if they wanted to check whether Soli had actually worked on the brief, they would check this last page of the brief, and if his tiny scrawly handwriting was on it, they would say, yes, Soli's paw marks are here, so we can be sure that he has worked on this. So this is, it's not about what he taught us as a lawyer, but also what he taught us as an advocate, how to be absolutely polite in court, never raise your voice. There is never any question of any emotion or excitement in that sense. I mean, we have come a very long way today, where just a few minutes back, the Chief Justice of India had to rebuke us. He said, because doesn't matter what your personal views are, you cannot shout at each other across the aisle. And he rose for 10 minutes and came back and dictated an order. So times have changed. I do not know how Soli would have reacted to this change of times. He was, as you all know, steeped in constitutional values, empowerment of women, gender justice, freedom of press, which is how he first drew attention to his legal career around the time of the emergency. He was also a wonderful lawyer on technical aspects. On indirect taxation, he could pick up a brief and do it without any research, and of course commercial law. He taught us not only how to think as a lawyer, but how to deal with situations in court. He taught us also that in order to be a top professional, it is not necessary for us to stop living our lives. And he was an example in himself. As you all know, he was passionate about music. He both listened to and practiced jazz. He had a passion for books, and his personal library, by which I don't mean his legal library, his personal library was full of books which were so interesting that sometimes when we waited for conferences, we were busy going through his library. But he was conscious of the limits of all that when you are a professional, because one day we were trying to persuade him to come with us to the book fair, which was of course across the road. And he said, the problem is that there are more books in my library than I have time to read for the rest of my life. So these things stay with you forever. He authored a brilliant book on Mr. Nani Palkiwala, along with Mr. Datar, I think. And that is an amazing study of a great lawyer, which also reveals a lot about himself as a lawyer. And perhaps you may recollect, we miss this nowadays, he also used to write a column in a daily newspaper. And the topics were endless. They were not legal topics. There were all kinds of topics, and you could follow the wide interests of the person by reading his columns. So it's a real pleasure that this organization has been hosting from the very beginning the Soli lectures. Mr. Santan Krishnan was careful to be the first off the block and we held the first lecture, I think, on his first birthday after he passed away. Today, we are celebrating his life and his values, because you will hear now from from Justice Suryakant on one value which I think Soli honored above everything, that is human rights. He was even a rapporteur appointed by the United Nations on human rights in Nigeria. Thank you very much.
Thank you, Jaideep sir, for this insightful personal reflections and the working style of Mr. Sorabjee. And now I would request Mr. Rakesh Khanna, Senior Advocate and former SCBA President, to come and introduce the Chief Guest, Justice Suryakant, to the audience.
Honorable Mr. Justice Suryakant, Honorable Mr. Justice K.V. Vishwanathan, Honorable Mr. Justice Prasanna B. Varale, Learned Attorney General for India, Mr. Venkatramani, my esteemed colleagues, Mr. Jaideep Gupta, Senior Advocate and Council Member of CLA, Ms. Nisha Bagchi, Senior Advocate, Mr. R. Santhana Krishnan, Honorary Life President of Commonwealth Lawyers Association and President of Nivaran. Incidentally, I must tell you that it is the efforts of Mr. Santhanan that we started Nivaran somewhere in 2020, just before the pandemic started. And I'm very happy to announce that with these efforts and efforts of Mr. Rajiv Datta and J.M. Sharma, that the Nivaran is now registered last week. I must also acknowledge the Siddharth Sijoria Advocate and co-chair of Young Lawyers, Commonwealth Lawyers Association, Mrs. Sorabjee, who is with us online, Vice President of SCBA, Mr. Pat Joshi, Secretary of SCBA, Mr. Rohit Pandey, and other office bearers, President SCORA, Mr. Vipin Nair, and all distinguished guests, and my dear brother and sister colleagues. Today's topic, which my Lord Justice Suryakant has chosen, is itself shows not only the topic was very dear to the hearts of Ms. Soli Sorabjee, but also our speaker today. In service of today's theme, let me first start by invoking the fifth mantra of 60th Sukta enshrined in the fifth mandala of the Rigveda, which I read. Ajayishthaso akanishthas etesam bhratro vavridu sobhaya, meaning no one is superior or inferior, all are brothers, all should strive for the interest of all and progress collectively. As a side note, it would be germane to note that this ancient and profound wisdom, which innately underpins the very idea of human rights, has received the due judicial recognition within the modern Indian jurisprudence under a separate opinion authored by the Chief Justice, Honorable Mr. Justice Deepak Mishra, as his Lordship was then, in the case of Common Cause versus Union of India, more colloquially known as passive Indonesia judgment. Continuing on the same tangent, verses 58 of chapter 69, enshrined in Karna Parva of Mahabharata, famously asservate that Dharanata dharma ityahu dharmo dharyati prajaha yasayat dharana sanyuktaha sadharma iti nishchaya, meaning dharma or law sustains the society, maintains the social order, and ensures the progress and well-being of the society. Although the construal of dharma is very wide and there is no contemporary English word for it. It has now become a widely accepted loan word in all modern English dictionaries. It denotes a multitude of variegated designations like obligations, conventions, customs, guidelines, injunctives, authorizations, principles, standards, and models. Dharma was like a cosmic law that applied to every person in the ancient Indian society by virtue of being born a human. It had trans-temporal validity. It guided the king in governing the state while also concomitantly guided the people in the conduct of their life. To that effect, it would also be pertinent to note here that the contemplation of concept of dharma is manifestly commensurable with the Western understanding of human rights, such as Kant's deontological ethics. Both corresponds with the university, innate rights, and standard of morality. Lastly, and before adverting to my actual assigned duty for the today, I must also place before you all a very pertinent verse of Samajana Sukta of Artha Veda, which would further give you all another glimpses into the independent development of human rights in India. And the same reads as, Samani Prapa Sah Vonabhaga Samne Yoktre Saha Vo Yujmani Araha Nemi Miba Mitaha, meaning all the equal rights of articles of food and water, the yoke of the chariot of life is placed equally on the shoulders of all. All should live together in harmony, supporting one another like the spoke of a wheel of the chariot, connecting its rim and hub. Unquote. It would be apposite to note that the echoes of ancient equity is also evident in the jurisprudence pronounced by our Venerable Chief Guest today. My Lord Justice Suryakant, who as then Chief Justice of the Honorable High Court of Himachal Pradesh, had eruditely held in the case of Madan Lal versus State of Himachal Pradesh, and I quote, "Potable water and electricity are integral parts of the right to life within the meaning of Article 21 of the Constitution of India. These are basic necessities for human being and can well be termed as essentials of human rights." Unquote. With that, I can neatly segue to my actual task at hand here. Although His Lordship Justice Suryakant needs no introduction, custom dictates that I must endeavour to do so as briefly as possible. My Lord Justice Suryakant hails from a humble background. His Lordship completed his graduation from a government postgraduate college, Hisar, in the year 1981 and subsequently obtained his LLB degree from Maharishi Dayanand University, Rohtak, in the year 1984. His Lordship began his practice from Hisar District Court and later shifted to Punjab and Haryana High Court at Chandigarh in the year 1985. His Lordship was appointed as Advocate General of Haryana on 7th of July 2000 at the age of 38, becoming the youngest Advocate General to have ever served on that post in India. In recognition of His Lordship's legal acumen and astute knowledge of law, Justice Suryakant was subsequently designated as Senior Advocate in March 2001 and continued to hold the office of Advocate General till His Lordship's elevation as Permanent Judge of Punjab and Haryana High Court on 9th of January 2004. Justice Suryakant was appointed as Chief Justice of Himachal Pradesh High Court on 5th of October 2018 before being elevated to the Honorable Supreme Court on 24th May 2019. His Lordship has served as member of National Legal Service Authority for 2 consecutive terms and is presently member of number of committees of Indian Law Institute. Furthermore, His Lordship's inclination to academics can be evinced from the fact that he not only pursued his LLM degree from the Directorate of Distance Education, Kurukshetra University in the year 2011, but also has the distinction of standing first in the entire course. Justice Suryakant has always been regarded as keen debater by all his fellow colleagues since his student days and is also considered as passionate environmentalist by all acquainted with him. His Lordship is associated with various national and international NGOs and law associations devoted to the cause of protecting our environment. Justice Suryakant, I can safely say, is the darling of our bar in Supreme Court and is regarded and his Lordship is regarded by all as being extremely patient, compassionate, and an innovative jurist who is committed to the ethos of justice. Speaking at the second Supreme Court of India annual lecture series, my Lord Justice Suryakant had reiterated that, and I quote, "The commitment of Supreme Court of India to prioritize the rule of law and value of significance of human rights need no emphasis. The apex court has consistently demonstrated a nuanced understanding of global progress in human rights discourse and the legal frameworks." Unquote. To that effect, it would be germane to note that in his address delivered at Chandigarh Judicial Academy, His Lordship has previously asseverated that, and I quote, "Article 21 is heart of our Constitution, and around this almost all our human rights jurisprudence has been shaped." Courts, though repeated exercise of judicial review over 70 years of constitutional jurisprudence, have widened the ambit of Article 21 and have consequently in many ways strengthened the individual's rights. Unquote. My Lord, on behalf of the Commonwealth Lawyers Association and Nivaran, the mediators of Supreme Court of India, as well as the Society of Lawyers in India, Soli, I am extremely grateful to your Lordships for graciously accepting our humble invitation to deliver the third Soli sorabjee lecture on human rights and development in India. Thank you.
Thank you, sir, for sharing the insightful thought and for a brilliant introduction of Justice Suryakant. Now I would request Justice Suryakant to kindly come and deliver third Soli sorabjee memorial lecture.
Thank you, Mr. Khanna, for so many kind words for me. My esteemed colleagues, Honorable Mr. Justice K.V. Viswanathan and Honorable Mr. Justice Prasanna Varale, Honorable Judges of the Supreme Court of India, Sri R. Venkatramani, Learned Attorney General for India. As we are informed, respected Mrs. Sorabjee is also with us online. Vice President and other office bearers of the Supreme Court Bar Association, Mr. Jaydev Gupta, Mr. Rakesh Khanna, learned senior advocates on the dais, Ms. Nisha Bakshi, learned senior advocate, Mr. Siddharth, a very distinguished team of senior advocates from the Supreme Court Bar Association, members of the Supreme Court Bar and different High Courts Bar Associations, Sri R. Santhan Krishnan, President and other office bearers of the Commonwealth Lawyers Association, President and members of the Society of Lawyers in India, President and office bearers of Nivaran, distinguished dignitaries and members of the legal fraternity, a very good evening to all of you. I extend my heartfelt congratulations to the Commonwealth Law Organization and other co-organizers for having successfully organized this third edition of the event in memory of Sri Soli sorabjee. Such programs undoubtedly are crucial in upholding the enduring legacies of legal titans like Soli sorabjee, ensuring that the legal fraternity continues to glean from their invaluable ideas, principles, and wisdom. There is undoubtedly, we all know that Sorabjee was a lawyer par excellence, a prolific writer, and a fervent advocate for the protection of human rights, a topic that is central to my discussion today. Throughout his law practice, Soliji was at the forefront for helping the disadvantaged and the oppressed, leading his expertise to cases that laid the foundations of contemporary Indian constitutional law jurisprudence. Mr. Soli sorabjee distinguished himself as a stalwart defender of the human rights and the vital right to freedom of expression, solidifying his legacy as a tireless proponent for justice and civil liberties. Let me begin with a personal note. I always regard Soliji not only as a guide and a mentor but also a dear friend whose passing left a profound void. One of my initial interactions with Soli was way back in somewhere in October 2000. As Mr. Rakesh Khanna pointed out, I took over as Advocate General. I was 37 years old when I took over. It was in July 2000. I didn't have much exposure as was required. There were multiple responsibilities, cabinet meeting to looking after the litigation in High Court. I was also asked that entire litigation in Supreme Court also has to be looked after. There were some important matters before different forums also. I am very briefly pointing out. One of the matter we had an international arbitration dispute that was with one of the state corporation with a German bank. And after taking over, the file was sent to me for my opinion. I found that we have already spent crores of rupees on litigation and there was no way to see that something positive could happen. My advice was that we should try to settle the dispute amicably. Then issue arose that what should I do? So I thought that I must contact Mr. Soli sorabjee. He was the Attorney General of India at that time. I gave a call and very promptly I got a response from him calling me to meet him. At that time, Soliji has undergone knee replacement surgery and he was, I believe, that the official residence where I met him. He very promptly helped me, spoke to some senior law officer in Germany and immediately asked me to travel to Germany and have a meeting one-to-one with the bank. I led a delegation, went to Frankfurt. One senior law officer of Germany, he mediated and it took hardly 1 hour for us to settle the dispute. I was authorized by the cabinet to sign the check. I signed then and there and the matter was over. I came back and went to Soli and thanked him and requested him that there are very crucial matters in Supreme Court where the state interest was at stake. And I requested him that despite the fact that our fee structure as such is not very attractive, but I would request you to accept those briefs. He was very kind and he accepted some of the matters where I requested him that we like that an attorney should appear for us. The other very important memory which I always cherish was we had a water dispute, the Haryana and Punjab, that SYL dispute, as all of you know. Justice G.B. Patnaik and Justice Rumapal's bench decreed our suit. The suit was filed by State of Haryana. That was in January 2022. These kind of judgments are sometimes, it becomes very difficult to get them implemented, and the issue arose that how to deal with. Obviously, Punjab state also, they had their own viewpoint and they politicized the issue, and it became quite difficult that how to that decree should be get executed. The state assembly, led by the entire government, chief minister and everyone in the opposition, they decided to meet the prime minister. An appointment was sought, and the then prime minister Sri Atal Bihari Vajpayee gave us time. Then it was resolved that I will speak for 10 minutes and represent the state's viewpoint. I remember that was a great opportunity for me to speak before the prime minister. The entire cabinet was there, all senior functionaries were there, and Soli was also there. When I spoke and put up the viewpoint, I still vividly recollect that Soli very firmly supported me and that told that there was a court decree and that must be respected, and the union should intervene to ensure that if the judgment could be given effect. Well, after that, as Rakesh informed on my elevation, the situation was different. Then you start leading a different kind of recused life, and you don't have that continuous relationship. But I was surprised in 2014 or 2015 somewhere. I got a call through one of the lawyer who was a common friend of Soli's, and he knew me also very well. He connected me, and Soli asked me that, Judge, are you interested to take membership of IIC? So I was a bit confused. I said, well, I don't mind, I will take. Kehta, no, you must take. And Judge, you must remember, either way you will end up in Delhi. The idea was that if I don't make to Supreme Court, I will come and practice here. And if I come to Supreme Court in any case, then I have to come to Delhi. I opted for it, and today I am member of IIC only because of Soli. In 2017 or maybe 18 beginning, there was a matter before me of a very big developer, real estate developer. He moved an application asking me to recuse in the matter. The reason was, he said that in 2004, when I was sitting with Chief Justice as the junior judge in the bench, I had delivered a very hard-hitting judgment against him in some other matter. This 2017-18 matter had nothing to do with 2018 matter, but he wanted me to recuse, saying that I am biased against him. I took a stand that I am not going to recuse myself on this ground. The matter was adjourned 2, 3, 4 occasions, and eventually one day, surprisingly, I found that Soli is sitting in the court, in the front row, not maintaining good health at that time. 2 juniors were there to assist him in the matter. He stood up and he started arguing the case. After 5-10 minutes, then I had to intervene and telling Soli Saab that, well, I don't mind to hear the matter on merits, but there is an application by your client asking me to recuse. So unless I decide that application, how can I proceed on merits? Soliji was not aware of it. He got puzzled. And then probably somebody whispered in his ear and he asked me, Judge, can you accommodate me with an adjournment? I was in any case keen to adjourn the case on that day. So I adjourned the case. Next time the Soli sorabjee didn't appear in the matter, one senior advocate from Supreme Court appeared. I dismissed the application, imposing cost of 5 lakh. Matter came to Supreme Court. The only modification was that the cost was enhanced to 10 lakh. So after that, in those days, then my name was recommended for elevation as Chief Justice. I also probably lost track of the matter. But then suddenly, that the lawyer friend which I was earlier talking about, he came to my chamber and he said, would you mind if I connect you with Soli Saab? And he is not maintaining good health. You please convey your best wishes also to him. So he connected me. And please see, Soli told me, Judge, your order I have read. This is the befitting reply you must give as a judge to all those who indulge in form shopping. That was my informal or formal last communication with Soli. After that, I left as Chief Justice in 2018. And then, of course, lost track of time. And I think eventually I lost Soliji also. Well, You all know about Soli's contribution. As a very young lawyer, he started the I think most historical, and I call it as the magnum opus case. Case 1 and Bharti appeared as a very young lawyer. And of course, all contribution by the prominent members of the Supreme Court bar in propounding the basic structure doctrine. Soli staunchly believed that this doctrine was crucial in safeguarding the tenets of federalism, preventing the subjugation of state to the center. He emphasized its role in preserving the integrity of free and fair elections, thwarting reckless constitutional amendments, and most significantly, I would say, protecting the judiciary's power of judicial review. To this end, during a lecture at the Oslo University in 2008, he expressed his views on the basic structure doctrine and said, and I quote, "In the Indian context and experience, there are tangible and substantial gains resulting from the basic structure doctrine and a bulwark against further erosion of basic fundamental rights." He also very prominently advocated the cause of fundamental rights in Menka Gandhi, then in Sunil Batra, R.S.R. Bomai. All these matters, a few of them I am quoting. Soli's erudite writings on human rights garnered widespread recognition and international acclaim, earmarking his reputation as a righteous defender of the Constitution's founding principles. He has authored one paper, all of you are aware, but I am just only relevant parts I am referring to. Indian Democracy, Economic, Social and Cultural Rights. That was published in the National Human Rights Journal. And there he says, in fact, that is the article that I made the basis of today's my discussion. I am just coming to the subject, but I am sorry for these preliminaries. The broad theme of my discussion is based on that article. There he explained, and very lucidly applying them to our present reality, the idea is thus to gain an intense understanding of Soli's vision and explore how these concepts can inform and shape future developments. In his paper, Soli examined the roles played by both Part 3 and Part 4. That's the basic thing which I wanted to highlight. Part 3 and Part 4 of the Constitution. He underscored the collective contribution of the fundamental rights and directive principles of state policy to the broader discourse on human rights. He endorsed leveraging these twin pillars of democracy to foster social and economic justice, thereby enriching the democratic fabric of our nation. His vision sought to harness these constitutional provisions to ensure that the benefits of democracy are shared equitably among all citizens of our country. With this as our foundation, let me embark on the understanding of the essence of human rights and its development within the Indian legal framework. Sometimes we keep on grappling to understand what actually human rights are. As I understand, human rights have been broadly defined as the activities, conditions, and freedoms that human beings are entitled to enjoy by virtue of their humanity, regardless of their status. These rights are often considered inalienable, interdependent, and indivisible, which means that they can neither be depends on the universal respect of such rights and actions of other members of society to the extent that such actions do not harm the other person's enjoyment of those rights. While human rights are commonly understood as a collection of fundamental moral entitlements inherent to every individual, they are far from being fixed or static. In my considered view, human rights are influenced by multiple factors and are often shaped by the environment in which they exist. Justice Krishna Iyer, in his book Dialectic and Dynamic of Human Rights in India, with his usual heavily loaded words, he defined human rights and says, those irreducible minima which belong to every member of the human race when pitted against the state or other public authorities or group and gangs and other oppressive communities. Being a member of the human family, he has the right to be treated as human once he takes birth or is alive in the womb with potential title to personhood. In many ways, the fundamental rights and directive principles of state policy are an expansion of human rights which we have broadly interpreted over time through a multitude of cases so as to afford increased rights and liberties to every individual in our country. But before we begin to trace the development and expansion of human rights through judicial process, we must talk ourselves how it came to be such an integral part of our constitution at the first place, how we thought of recognizing it, and for that we go to the Indian history. India has long been acquainted with the concept of human rights, with its principles deeply rooted in the teachings of many of our ancient texts, influencing our lives across centuries and epochs. Across the world, ancient legal systems were heavily influenced by its respective religion and faiths. In ancient Indian literature, texts like Vedas, Puran, Dharmashastras, as well as other legal books of that era, which put in place a comprehensive system of how to regulate the duties of kings and judges, while outlining judicial and legal procedures. At the heart of these regulations lay the central concept of dharma, which bound both kings and citizens, men and women alike. The term dharma is a broad and perhaps no equivalent word, as Rakesh Khanna also pointed out. In the English language, you don't find any adequately defined word. Dharma includes obligations, conventions, customs, and guidelines, a cosmic law that applies to every individual in society simply by virtue of being human. Etymologically, the term is derived from the root word dhri, which means that it upholds and sustains humanity, its values, along with the ideals of truth and righteousness. By integrating aspects of the body, intellect, mind, and the soul, the scholars of ancient India created a holistic character of dharma which could adapt itself to difficult conditions, status, and stations of life. Justice Gajendra Gadkar, in his book Historical Background and Theoretic Basis of Hindu Law, he remarked, and I quote, "The state is in that era was neither excessively sacerdotal nor paternalistic, as the king, like any other citizen, was subject to the same laws and regulations governed by dharma. Unlike the Western system, there was no concept of divine right vested in a king. In that regard, Justice Rama Joyce, he came as Chief Justice in our High Court. I was a very young lawyer. I argued some matters before him, good amount of cases before him. In his book Legal and Constitutional History of India, he explained that the primary objective of the kings in the ancient Indian system, as per the Raj Dharma, was only to enforce the law laid down in Dharmashastras. Thus, the idea of kingship was not to impose a new social order, but to uphold and adhere to the existing moral order. The concept of dharma also lent itself to a facilitating an independent judiciary, a hallmark of the ancient system. This has been extensively dealt with by Sri P.B. Mukherjee in his literary work, The Hindu Judicial System, the Cultural Heritage of India. That's the name of the book, where he sheds light on this system which predates the contemporary era of federalism, characterized by a monarchical structure featuring an independent judiciary and executive, both in form and essence. This arrangement was based on the premise that these principles were superior to king and rulers. That's very important. Actually, this was the root of the evolution of the principle of separation of power of the judiciary from the executive. Dharmic law was regarded to be above all human authority, which nobody or individuals, regardless of their supremacy, could abolish. Although ahimsa or non-violence has always been an inherent characteristic of Indian ancient cultural values, but Buddhism emphasized more on this concept. This philosophy brought forth the eightfold path, embracing the principles of humanism, compassion for all living beings, and reverence for life. Similar to Gautam Buddha, Emperor Ashok renounced his princely status and ardently pursued the path of ahimsa, tolerance, mercy, humility, and concern for all living creatures. Under his rule, multiple initiatives were launched to provide healthcare, education, and other social amenities, laying the foundation for the recognition of certain economic, social, and cultural rights for the citizenry. Then Chanakya, in his omnibus work Arthashastra, embodied postulations such as the Dandaniti or law of crime, which regulated the penal dimensions of human rights during the time of Mauryan Empire. The Arthashastra also provided for a justice administration system detailing the qualifications, independence, and impartiality of judges. It even conceptualized the modern day equivalent of an amicus curiae and incorporated certain rules of equity to be established between sparring parties. Thus, the rule of dharma applied to all individuals regardless of their status. During the reign of Akbar, I am coming from one period to another period, who ushered in a new era marked by his policy of reconciliation and tolerance. There was a strong emphasis on justice. Akbar's empire boasted nuances like judicial administration, which encapsulated modern theories such as due process of law, fair trial, and an independent judiciary. Akbar's rule as emperor was one which stood witness to the freedom of religion, trade, and even human rights to a large extent. Akbar was a believer of Sukhi Kul or universal tolerance and peace, which made this period one which had greater regard to human rights, justice, dignity, and the rule of law. I have picked up this historical background from a few authors, including Mr. Yogesh Tyagi. He has done a commendable research work in this regard. This is what the history book shows, that even in Jahangir's time, several of these tenets continue to be followed, with greater emphasis on access to justice to all. Jahangir, to this end, had supposedly arranged for a bell to be chained outside his palace so that no person was denied justice. History suggests that this progressive approach got a setback during Aurangzeb's regime. That setback continued till the inquisition by British forces, prompting, of course, one of the great human beings, as the history tells, was the last Mughal emperor Bahadur Shah Zafar, but then he was victim of the system. I will just, all of you know, बहादुर शाह साहब बहुत बड़े शायर थे. एक ही उनकी लाइन में उनकी हिस्ट्री को बात करूंगा. एवाए इंकलाब जमाने के जोर से दिल्ली जफर के हाथ से पल में निकल गई. But this is how Jafar, the victim of the circumstances at that time, was jailed, and he was, and that too jailed at a very far away place. You know many of his ghazals, and very great singers have sung those ghazals where he explained that the pain of going outside, and where he is wishing to have do gaz zameen for his ultimately when he leaves the world. But all those things are there. The British regime, of course, was responsible for this kind of unfortunate plight of Bahadur Shah Zafar. The subsequent British rule further aggravated this dark age of human rights in India, where basic civil, political, and economic rights and liberties were disregarded and ancient legal heritage was attempted to be dismantled. This period marked a time when the interests of Indians were systematically ignored, denied, and trampled upon by the English rulers. The struggle for independence represented the culmination of various demands, all rooted in the fundamental cry for human rights and human dignity. In response to the burgeoning freedom movement sweeping across the nation, the British government initially introduced the Government of India Act 1833, which included certain political rights. Subsequently, the Government of India Act 1915 came, promising equality of opportunity in public services, but all these measures proved illusory to the growing demand for civil rights and equality, which continued to gain momentum during our freedom struggle. In 1928, the Indian National Congress formed a committee tasked with examining fundamental rights. The committee proposed fundamental rights such as equality, personal liberty, and freedom of profession and religion, which were subsequently rejected by the Simon Commission. The Indian National Congress once again, through the Fundamental Rights and Economic Program of 1931, demanded certain basic freedoms to be considered by the then British government. But these hopes were once again derailed with the enactment of the Government of India Act 1935 by the British Parliament, which incorporated none of these demands and had no provision for rights branded as either fundamental or human rights. These actions of the British government only served to bolster the determination for Puran Swaraj, ultimately leading to the national eventual freedom movement. Now, in this background then comes the Constituent Assembly after we gain independence. The Constituent Assembly, who, as we all of are well aware, met for the first time on 9th December 1946 to frame the Constitution of India, and thereafter unanimously adopted India's Charter of Freedom in 1947, declaring India as an independent sovereign republic. It stated that sovereignty would lie with the people of India, and the government and its instrumentalities would derive their authority from those very people. That's what preamble now says. It provided that the Constitution would guarantee to the people justice, social, economic and political rights, equality of status and opportunity before law. A number of rights delineated in this initial Charter of Freedom came to be included in the preamble, then in other Part 3 and various other provisions of the Constitution. The Constituent Assembly, in drafting the Constitution, placed supreme importance on incorporating human rights. This emphasis on fundamental rights stemmed from the absence of civil liberties during British rule, the prevalent social conditions, societal divisions along religious, linguistic and ethnic lines, and landlords' exploitation of the peasantry class. All these factors really weighed in the mind of the Constituent Assembly in ensuring and guaranteeing that fundamental rights, which were actually a reshaped human rights, are guaranteed to all of us. The Constituent Assembly also integrated into the Constitution such rights which were inspired by the principles and essence of rights outlined in the Universal Declaration of Human Rights adopted by General Assembly. Additionally, the aftermath of the Second World War and the worldwide agitation for human rights strengthened the need for embedding the fundamental rights in the Constitution. These were all factors which really played a very vital role in ensuring the grant of fundamental rights to all of us. Eventually, we got our Constitution with 395 articles and 8 schedules, making it one of the most compendious constitutions ever adopted. Well, it needs no elaboration that the Constitution of India, as we know it today, acknowledges and enumerates a host of rights, such as the equality before law, the freedom of speech, expression and the right to life, personal liberty. Many of us still keep on wondering that why there is a need to focus on historical aspect of the human rights. I believe that many of the fundamental rights that we are familiar with today not only find their origins but have in fact been successfully practiced in Indian society since ancient times and certainly predates any other contemporary human rights laws or resolution. For instance, the idea of the king having to uphold the law of the land and also be subjected to the same law in many ways reminiscent of the right of equality before law and equal protection of law as today enshrined under Article 14 of the Constitution. Indeed, the provision of a free, fair and impartial judicial system to the masses. This one I am trying to build a point that even creation of a impartial judicial system to the masses is itself a tall acknowledgement of a basic human right. The establishment of a judicial system and ensuring access to it for the general citizenry to seek redressal for the violation of their rights, I am not talking fundamental rights, for violation of their rights, represents the recognition and guarantee of human rights principles. Individuals approach courts for a multitude of reasons, ranging from maybe they have a land dispute, somebody need maintenance, marital disputes, contractual disagreements, criminal matters, so many other disputes, which may not always directly correspond to violation of fundamental rights. Nonetheless, the very availability of a robust judicial recourse through such legal processes distinguishes a nation and underscores its commitment to justice and rule of law. If there was no judicial system, probably where the people would have gone for redressal of their routine civil rights, natural rights, private rights, personal rights. So it's not the fundamental rights only that judicial system is meant for. And that creation of judicial system, to my mind, itself is a recognition of one of the great human rights in our modern day post-constitutional era. It is thus evident that many of our present practices are informed by our past heritage and intrinsically connect with one of us. However, as explained earlier, these human rights have never been constant through the passage of time and have consistently been shaped by the winds of change. In the post-constitution era, what then remains to be observed is the judicial actions taken over time by the Supreme Court to expand fundamental rights and enhance the infusion of the directive principles of state policy into the fundamental human rights practices. The Supreme Court has expanded the scope of several rights beyond the literal language of the articles, and such are the rights not expressly even listed in Part 3 of the Constitution. Of course, after taking a restrictive view in ADM Jabalpur, the position gradually shifted to a more expansive reading of Article 21 in Menka Gandhi and series of other judgments which I before all of you are not to be cited, but all these judgments have the effect of widening the scope of personal liberty, ensuring that individuals were not arbitrarily deprived of rights such as the freedom to travel abroad or various other allied rights. This was for all intents and purposes a watershed moment in constitutional adjudication, paving the way for more expansive interpretation of Article 21. The series of subsequent judgments, whether Mohini Jain concerning right to education, Sunil Batra right of prisoners, Anuradha Bhasin right to access to internet, Kutuswamy right to privacy, to name a few, have further broadened the scope of Article 21. A whole host of other such rights have emerged as a result of expansive judicial interpretation, including the right to speedy trial, the right to free legal aid and in a criminal trial, and even the right to die with dignity. Then Unni Krishnan also declared the right to education as a fundamental right that have spurred a very positive legislative action also. I would like to briefly discuss and focus on the evolution of directive principles transitioning from a set of articles often overlooked in the Constitution to ones that have progressively gained more significance and application over the time. Soli in his paper, which I referred earlier, explained that the directive principles of state policy enshrined in Part 4 of the Constitution articulate the goals which a welfare state seeks to accomplish. They are intended to ensure equanimous justice to all by eliminating inequalities and disabilities and to achieve the equitable division of wealth among the members of society. The directive principles enshrined in our Constitution comprise social and economic rights such as the right to health, shelter, a living wage, work, nutrition, environmental protection, and various others. Each and every such right is the enunciation of well-acknowledged and integral human rights. directive principles were perceived to be not justiciable, but the Supreme Court began to incorporate these principles through spacious judicial interpretation and into fundamental rights, thus widening their scope and ambit. Then in Minerva Mail, the Supreme Court began the trend of harmoniously interpreting directive principles, the trend alongside fundamental rights, contrary to the earlier perspective that fundamental rights hold superiority over directive principles of state policy. Although directive principles had initially been included in the Constitution as guiding principles of governance, it was through the judicial innovation that these principles began to receive their due. Considering that something as primitive as the basic needs of human survival were not explicitly enumerated as fundamental rights, the Supreme Court began to read directive principles and fundamental rights harmoniously, complementing each other, since the right to live with dignity is not possible without the realization of economic, social, and cultural rights. For instance, in Francis Bouillon, the court observed the term life in Article 21 cannot be narrowly confined to mean mere physical existence, but includes the right to live with human dignity and bare necessities of life such as nutrition, clothing, and shelter. In other words, it encapsulates the famous adage, roti, kapda or makan. This marked the beginning of a series of decisions which guaranteed rights such as equal pay for equal work, way back Ranveer Singh, right to live in a pollution-free environment, MC Mehta, right to shelter, UP Awas Nigam, protection of marine ecosystems, S. Jagannath, right to health, Mohinder Singh Chawla. Incidentally, today, I and my brother, Justice Viswanathan, we have pronounced a very short judgment addressing the importance of human rights of certain marginalized communities, unfortunately facing the brunt of police authorities who include their names in history sheets or police diaries merely on the basis of caste bias or prejudice. Such preconceived notions, it's a very short judgment, but we have tried to explain that such preconceived notions render them invisible and voiceless victims of our society, striking at the very core of their right to live a life with self-respect, which is the core human right. Presently, in determining the reasonableness of restrictions imposed on fundamental rights, the court can take into consideration relevant directive principles of state policy. For that, the Supreme Court found a leeway in Mirzapur Moti Qureshi in state of Gujarat matter, where the court emphasized that in evaluating the reasonableness of restrictions imposed on fundamental rights, relevant considerations should not be limited solely to those specified in Article 19 or Part 3, that was the subject matter of that case, but should also encompass directive principles outlined in Part 4. The two small issues which I want to correlate with the human rights principles is the rights of the victims vis-a-vis the right of an accused. And that's my opinion, which I have tried to build up in two judgments also. There is a fairly well advanced jurisprudence in our country recognizing the human rights of accused or under trials, but unfortunately not much was done initially towards recognizing the corresponding human rights for the victims of the crime. Under the Indian legal framework, whether statutorily or otherwise, accused persons have been granted numerous rights, such as I was earlier quoting, the right to know the grounds of arrest, the right to be produced before a magistrate without any delay, the right to a speedy trial, the right to legal aid, the right, of course, certain rights, of course, not to confess, and all these things the accused have got right. But there is not much focus on the victims and their rights. India has, of course, through the Code of Criminal Procedure and judicial precedents, developed a sweeping set of rights that are now possessed by the victims also. This may be in stark contrast to perhaps the a developed country like United States of America, which passed the Crime Victims' Rights Act only in 2004. India, on the other hand, demonstrated one of the earliest responses in discussing the rights of victims in cases such as the Delhi Domestic Working Women's Forum, that was in 1995, where parameters were issued towards assisting rape victims through steps such as legal representation, protection of anonymity, assistance of the police station, among others. There have been far-reaching changes and mechanisms implemented, especially for the victims of domestic violence and sexual assault, through expansions in the legislative framework, such as Prevention of Women from Domestic Violence Act 2005. The provisions of the counselors at police station is one of the judgment, and there are a lot of now statutes also. Protection officers for victims of domestic violence and one-step centers for victims of sexual abuse are several such salutary instances, both statutorily and judicially. Measures have been undertaken towards ensuring heightened women's safety, compensation for rehabilitation of victims of crime, and guidelines toward the extent of victim participation necessary in criminal proceedings. For example, in Privartan Kendra, the inadequacy of compensation being paid to acid attack victims was addressed, and it was suitably enhanced, building once the exhaustive guidelines already set out in this regard by the Supreme Court in Lakshmi case. When I was in High Court, I was heading a full bench, and in Tata Steel Limited matter, there was huge bunch of cases, but Tata Steel was a 138 complaint matter. Ultimately, that was the lead case, and probably that was the first judgment as I could find out at that time. I had the opportunity to include and deal with a detailed analysis of victims' rights in India. In the full one judgment which I authored, I highlighted the plight of victims being the de facto sufferer of the crime, who had no participatory right in the adjudicatory process and was relegated to be a mute spectator, thus making them yet another unfortunate instance of, I have coined the term, invisible victims of the justice delivery system. But then I grabbed the opportunity in Lakhimpur Kheri case when I was writing the judgment for 3 judge bench. There I have very exhaustively and with an extensive analysis on the meaning and extent of victim's right. The 3 judge bench, we have acknowledged the victim's right to be heard at the different stages of trial, even including at the stage when you grant bail in a heinous crime. As I reach the climax of sharing my viewpoint, it becomes clear that human rights have been an intrinsic part of India's culture and heritage since the very inception of its civilization. The discourse surrounding human rights holds a significant importance and position in judicial adjudication in the present day. As we have discussed, human rights are intended to be highest moral precepts and political ideals to which nation states are expected to adhere. Human rights trace their origins to the extensive political movements that emerged during the Cold War era, which significantly contributed to further dividing the world into distinct communities. Presently, the discourse on the subject of several jurists often characterizes human rights as the gift of the West for the rest. There is a prevailing belief that the imposition of international human rights treaties mirrors cultural imperialism akin to colonial endeavors of Western nations in the past. Certain scholars even argue that the adoption of universal human rights is impractical in a world marked by cultural plurality. Perhaps it is necessary to distinguish between the universally and uniformity of human rights. There might be a pressing need for the West to highlight the shortcomings of the current human rights regime prevailing in the developing world, as they often refer to us, and adjust policies accordingly. Instead of pursuing a one-size-fits-all approach, there should be a flexible approach better suited to the needs of an increasingly diverse world. Moreover, for these changes to be acceptable, both developing and developed nations should be held to the same standard, considering that almost all countries have their own unique set of issues that require attention. This approach would be more equitable than singling out certain developing nations for criticism. I will just take 2 minutes additional, but now I remember one instance and therefore I can quote it. In 2009, I had gone to Cape Town for an international conference on environmental issues. Eventually, I found that India was not being represented by any very senior functionary there. One of the honorable judge of the Supreme Court was supposed to lead our delegation, but because of some last moment personal difficulties, he also could not make it. So eventually, I was the only person left to represent India along with some junior level officers there. The Chinese delegation came and met me. Initially, when I drafted my speech, I was supposed to deliver the valedictory lecture. I thought I will talk of rule of law, and maybe that because when talking rule of law, I might unwittingly would have criticized the China also. But then when Chinese delegation came and they said we should adopt a very same uniform strategy, being the all developing nations, I told them that all right, I will consider it. But in 2 days in different sessions, I realized the same thing, that how developed nations are having their perceived biased and prejudged notions about the developing country. And they were lambasting us like anything. But only one instance which I thought that I am sharing it. I told them in my speech one thing. I said, please try to visit India and travel by train. You people are behaving like passenger psychology in India, that once I have entered the coach, I will not allow other passengers to enter. And I said, this is how the developed nations are behaving with us. That of course, my remarks went very well and we were able to really corner them in that conference. I would say that it is pertinent for us all to acknowledge that in today's rapidly evolving world, we are confronted with unique challenges to human rights and fundamental freedoms. Laws on human rights must evolve. Guidelines on contemporary issues such as gender equality, surveillance, data privacy, artificial intelligence, digital security, and most importantly, environmental concerns. Addressing these new challenges should not diminish the significance or commitment to the foundational principles that were already established, or the importance of principles still evolving, such as victims' rights or invisible victims of adjudicatory system. Nevertheless, the tower of human rights will always be constructed upon the basic foundation of human survival. These fundamental necessities will forever remain at the core of what constitutes the most basic human rights, that is, a vigilant society that has a series of legitimate expectations in our constitutional regime. And what is that vigilant society? दुष्यंत कुमार साहब की एक नज़म है, उसकी 4 लाइनों में खत्म कर रहा हूं बात को. व्हाट इज दैट विजिलेंट सोसाइटी? और दुष्यंत कुमार साहब ने कहा, वो आदमी नहीं है, मुकम्मल बयान है. वो आदमी नहीं है, मुकम्मल बयान है, माथे पे उसके चोट का गहरा निशान है. आप प्लीज एक एक वर्ड देखिए दुष्यंत साहब का. वो आदमी नहीं है, मुकम्मल बयान है, माथे पे उसके चोट का गहरा निशान है. सामान कुछ नहीं है, सामान कुछ नहीं है, फटे हाल है, मगर सामान कुछ नहीं है, फटे हाल है, मगर झोले में उसके पास एक संविधान है। और लास्ट लाइन दुष्यंत साहब फिर उसके बाद कहते हैं, उस सिरफरे को यूं नहीं बहला सकोगे, यू कांट, दीज वर्ड्स विल नॉट गोइंग टू सर्व, यू कांट डू एनीथिंग विद लिप सर्विस। उस सिरफरे को यूं नहीं बहला सकोगे आप, वो आदमी नया है मगर सावधान है। थैंक यू वेरी मच, थैंक यू फॉर गिविंग दिस अपॉर्चुनिटी।
Thank you so much, Justice Suryakant, for this fantastic lecture and for sharing personal anecdotes with Mr. Sorabjee. And I think you have done a truly justice to the topic, because you have trailed the development of human rights, starting from the ancient civilization and taking it through the Mughal era to the freedom struggle movement, and discussing what happened during the time of framing of the constitution, and how judiciary has played an important role in expanding the scope of human rights. And with that, I will now invite Ms. Nisha Bagchi ji to please give her closing remarks for today's session.
Honorable Justice Suryakant ji, Honorable Justice Vishwanathan ji, Honorable Justice Varale ji, Learned Attorney General for India, Mr. Venkatramani ji, my colleagues on the dais, Mr. Jaideep Gupta, Mr. Rakesh Kumar, Mr. Santhanam, Mr. Siddharth Sijale, and friends. Firstly, thank you, Your Lordship, for this illuminating discourse on the facets of human rights. I am also touched by your thoughts on my senior, Soli Sorabjee. Having been a junior in his chamber and the only lady junior to be designated senior by the Supreme Court, I deem it my privilege to be a part of this memorial for a senior whom I remember with a sense of respect, for a teacher par excellence. Being the last speaker today made it very difficult for me to choose my content, but my closing remarks are in 3 short points. Firstly, my perspective from the chamber of Mr. Sorabjee. Being a junior to him was every day a very challenging experience. We started each brief with a meticulous breakdown of facts. We had to find out where the cookie crumbled. When we placed all the facts in dispute in the real time scale, this was what we got to. The next step, he always insisted, was go back to the statute. So every time you have a set of facts, you reread the statute. You find something, a special dimension relating to every case. So it was text and context for each and every brief. After that, during the briefing was the most interesting part. He would locate the equities in the dispute. That was very important for him. He was always a very fair-minded person. So he would locate the equities in the dispute, and then he would play the devil's advocate. So we would hear in the chambers all the questions that the judge would ask a little short while later, and very often in the voice of and the exact tone and tenor of the judge, the concerned judge. He was an excellent mimic. So this was an instructive experience. Very briefly, these were what we found and we learned. This was an instructive experience. His innate fairness, highly ethical and fair presentation, and immaculate court decorum were a lesson for all. He commenced his legal practice in 1953 in an era of the nascent constitution. He evolved as a champion of human rights, successfully persuading courts against violations of fundamental rights, especially during the emergency. His commitment to human rights is writ large in the numerous articles penned by him. Going through his writings, they record his essential belief in the dignity and worth of each individual as being precious, and invaluable. He wrote that justice is the goal of every civilized society and the moral imperative of every government. He was of the view that, that abiding and deep satisfaction in a lawyer's life is when by his efforts the human rights of the exploited and the downtrodden are at times vindicated by the court. The music enthusiast in him read social justice as the signature tune of our constitution. He viewed law as a service-oriented profession, far removed from the laws of demand and supply. He has left behind an enormous legacy and will continue to inspire generations of lawyers to come. It is no wonder that many legal luminaries and a number of designated seniors have emerged from his chamber. His interpretation of the Attorney General's office as a guardian of public interest and promoter of human rights was welcomed by the legendary Nani Palkhiwala as a new stage of evolution of public law in India. His legal practice was of a rich canvas, showcasing his contributions across the entire spectrum of legal practice. Indirect taxation was what I mainly worked at in his chambers. Lastly, the perception on human rights in India, the concept of human rights dates back to at least the Vedas. This was interpreted by the Supreme Court in Kapila Hingorani's case with the shlok that has already been quoted by Mr. Rakesh Khanna. Basing on that quote, the Supreme Court held that the right to equality of all human beings has been declared in the Vedas, which are required as inviolable. To emphasize the dignity of the individual, it was said that all are brothers and all are the children of God. No one is inferior or superior. Similarly, the Atharva Vedas stressed that all have equal right over natural resources, all were equally important like spokes in a wheel. Both the Rig Veda and Atharva Veda declared the cooperation between individuals is necessary for happiness and progress. Pertinently, in the said judgment, the Supreme Court also read that the Universal Declaration of Human Rights in 1948 was similar to the Declaration of Equality made in the Rig Veda. It therefore perhaps falls into place that it was an Indian, Mrs. Hansa Mehta, who piloted the transformation from all men are created equal to all human beings are born free and equal in dignity and rights in Universal Declaration of Human Rights. This was a paradigm shift internationally. In Thota Shesharatnam, the concurring opinion of Justice Ramaswamy highlighted the equal status of women in economic, socially and culturally in the Vedic society, as well as the teachings of Gautam Buddha and the expressed viewpoints of the father of the nation, Mahatma Gandhi, and the Nobel laureate Sri Rabindranath Tagore. Thus, human rights for all human beings are timeless in India and are now inbuilt in the hallowed phrase, "We the people of India." The march of human rights in India has now been eternalized in the judicially evolved formula of recognizing unenumerated rights as being implicit in enumerated guarantees, rights to privacy, rights to live with dignity, etc. Thank you. I am also thankful to the Commonwealth Lawyers Association for giving me the opportunity to speak in this memorial program. Thank you.
So before closing this ceremony, we would like to extend our thanks to Mr. Vinay Ahuja of Mohan Law House for streamlining this today's session on YouTube. And also, I would say thanks to everyone who's present here, honorable judges of the Supreme Court, Sri Attorney General Justice Suryakant for taking your time and delivering this wonderful lecture, dignitaries on the panel. And with this, we would formally close the session for today. Thank you so much for coming and taking the time.